All right, sorry about that, folks. All right, well, we'll get started. This is Eric Hauge. I'm the Executive Director of Homeline, and you are joining us today, and us being Eric and Homeline's Managing Attorney, Mike Vraw. You're joining us on Wednesday, June 24th of 2020 at 1:30 in the afternoon for our weekly webinar covering tenant landlord legal issues during the COVID-19 pandemic. We've been doing these for every week since about mid-April, and we'll continue to do them. Again, reminder what Homeline is. We are a statewide nonprofit organization. We provide, our main service is a free legal hotline that any renter in the state can call or email us and receive free and confidential legal advice. We have staff that speak languages, 4 different languages: English, Spanish, Somali, and Hmong. So renters can call and get legal advice in their language. Again, a reminder, we're doing these every Wednesday at 1:30 in the afternoon for the foreseeable future, and have been doing them since mid-April. And 1:30 on Wednesdays for landlord, for an audience of tenants and advocates, and on Thursday afternoon for an audience of landlords and managers. All of the recordings for our webinars are available on our website. We now have a tab up at the top right of our website that has a drop down for a variety of COVID-19 related resources, including general legal advice, information, registration for future webinars, and links to recordings of the previous ones. Before we get started here, and again, we had plenty of folks submit questions in advance. So Mike's going to go through some of the basics, talk a little bit about a new topic, and then we'll get to questions that were submitted. I wanted to share just briefly before we get started, just a heads up that Homeline has a program. I know there's a lot of service providers, advocates on these calls, and so I thought this was a good opportunity to just share brief information. We have an AmeriCorps VISTA program where we have a cohort of up to 8 tenant AmeriCorps VISTA members. A VISTA is a volunteer in service to America. It's like a domestic Peace Corps type position for 1 year for individuals interested in doing service. And our cohort is basically, we're asking organizations, service providers, advocates to apply. I'm going to put in the chat the link to the where organizations can apply. So again, this is basically to apply to be one of the organizations that would host a 1-year AmeriCorps VISTA individual. And the project is specific to building the capacity of these types of nonprofits and organizations to engage, organize, and support renters. The link is in the chat. It is due August 3rd. And we encourage, if you're interested, Greater Minnesota, or in the metro area, if you're interested, take a look at that and consider it. All right, so with that, I'm going to hand it over to Mike, our managing attorney, to get started.
Thanks, Eric. All right, so today we are going to quickly recap the main topic that we talked about at virtually every one of these sessions, sort of trying to figure out when evictions could be filed again. And then we're going to dive into a new topic, something that I'm sure none of you have heard because, well, I finished the speech this morning. I actually gave a similar one yesterday. There were 11 people that watched it. It was a group of lawyers, but no, this is the first broadcast information about all this information that I'm going to be presenting, where we're sort of talking about a conservative baseline minimal estimate to how many evictions are likely to be filed and maybe when they'll be filed once the moratorium is lifted. But to recap where we are, right now we have 2 main hurdles for a landlord that they have to get past in order to be able to file an eviction legally in Minnesota. The first is a state hurdle, and that hurdle was put in place by the governor through an executive order that is tied in time to the peacetime emergency declaration. The peacetime emergency declaration works in 30-day increments. And we are now, let's see, the first one started in March, went was renewed again in April, was renewed again in May, and has now been renewed in June. So the one that we have currently will expire on July 13th of this year. Now, the governor can, once again, extend the peacetime emergency declaration if the governor so chooses. If the governor does that, a special session with the legislature is immediately triggered. And how the state moratorium will end is one of, I guess, 3 ways that I can think of how it will end logistically. One is the governor will decide. The governor gets to decide this unilaterally to declare these peacetime emergency declarations. They have the power to do that under statute. So the governor might decide today, I guess, in theory, hey, things look good with COVID-19. The cases are down. There's fewer hospitalizations, fewer fatalities. So we're going to pull back on the peacetime emergency declaration. And with that, the eviction moratorium would end as well. So that could happen at any point. The next way it could end is the governor simply decides not to renew this. So July 13th rolls around, the governor stays silent on it. I guess it would just lapse if there's not an extension. This isn't the kind of thing that we deal with normally, so it's sort of hard to know the logistics of how it would play out, but I think that's how it would work. The last way it can end is that the legislature can end the peacetime declaration. But both chambers of the legislature would have to do that. So the Senate is controlled by Republicans in Minnesota, the House controlled by Democrats in Minnesota, and the governor is Democrat. On June 12th, the Minnesota Senate voted to, the Republican-controlled Minnesota Senate voted to end the peacetime emergency declaration, which would have stopped the moratorium on evictions. Landlords would have been able to file evictions in. But the House, the Minnesota House did not vote to end it. Pretty substantial number of votes missing for the House to end the peacetime emergency declaration. So we're still in the peacetime emergency declaration because of that rule. And a landlord can't file an eviction for pretty much anything right now, at least almost all the main things that they typically file evictions for. The number one reason being, of course, non-payment of rent. Well over 90% of Minnesota evictions are for non-payment of rent. I'm not going to go into the exceptions this time because of the big topic that we're taking on, along with a lot of questions that have been submitted in advance this week. The other hurdle, though, that a landlord has to get past in order to be able to file an eviction in Minnesota or any other state is federally based. Now, this is rare. We don't have a lot of federal intervention in landlord-tenant law generally. It's almost all state law specific and sometimes even city law specific. But there is a federal prohibition against evictions at the federal level right now. It's found in what's called the CARES Act, which is not just about housing, not just about evictions. It's about a lot of things. But it is passed, once again, we had a bipartisan group there. So we had the Democrat-controlled House, the Republican-controlled Senate, President Trump a Republican as well. And the CARES Act bans evictions from being filed until July 25th. Now, this was declared back in March, so it was very far into the future when this was declared, but it's starting to close in on that time now. Also, if a landlord is covered by the CARES Act, then the landlord has to give a 30-day notice. And they can't do that until July 25th rolls around. So they have to wait till July 26th to give the 30-day notice. So if a landlord is covered by the CARES Act, they can't file an eviction until late August. That's the earliest they could file. Now, the harder question is who's covered by the CARES Act. That is very difficult to figure out. There's some places that are easy. Any kind of obvious federal subsidy that's involved is going to be covered by the CARES Act, but also smaller places, 1 to 4 units, where there's a federally insured mortgage like Fannie Mae or Freddie Mac would be covered by the CARES Act. So not only that, we actually have to start thinking about this now is if the governor extends past July 25th, then the Minnesota moratorium goes past the CARES Act moratorium. But still, the CARES Act 30-day notice requirement is still in play. Whenever the Minnesota moratorium gets lifted, the CARES Act prohibition still requires a 30-day notice once July 25th rolls around. So landlords might still have to give a 30-day notice if they're in the affected sector, the CARES Act covered rentals. And our best guess, nobody's ever asked this question before COVID-19 hit, how many places would be covered by the CARES Act? There would have been no reason to ask it. So nobody's really sure exactly how many of these would be. And it's almost impossible for tenants to know if their landlord is covered by the CARES Act. It's something that in most other states where they've opened the doors back to evictions being filed again now, the courts are requiring that landlords either provide documentation that the CARES Act does not cover them, or at least a sworn affidavit, so they're under penalty of perjury, that the CARES Act doesn't cover them. The landlord can find this out pretty easily. They're the customer that holds the mortgage. They can go to their bank and find out from the bank, hey, does my mortgage have federally backed insurance or not? For the tenant to be able to find that out would probably require discovery. Evictions happen really quickly, so the discovery is limited and there's not enough time. It's probably the only way it can be determined is if the landlord produces something or swears under oath at the very least that they're not covered by the CARES Act. But we'll see if the Minnesota Supreme Court decides to require such a thing. We would hope that they would, as other states have done. Okay, let's go on to trying to figure out the size of the eviction wave, which is, I know, why many of you signed up. We had a substantial increase in people that are watching us today over last week because of this reason. And that was on purpose. We wanted to make sure that as many eyes can see this as possible. So I'm going to walk you through how we're kind of coming up with the numbers that we're coming up with to start. So here's some basics. Over the last 5 years, you can see it on the screen, 16,000 plus evictions have been filed in Minnesota. Okay. Now, not every eviction is where somebody lives. They're not all residential. There are commercial rentals. So if somebody's renting a store in a strip mall and they don't pay their rent, the owner of the strip mall files an eviction against that commercial tenant. So it would show up as an eviction, an unlawful detainer, UD, whatever you want to call them. They're all the same thing, a court case filed against a renter or a tenant by the landlord to recover possession. An eviction is also the last step in a foreclosure process. So foreclosures aren't what they were 10 years ago, 2008 to 2011, somewhere in there. Foreclosures were really rampant in Minnesota and throughout the country. And we would see a lot of evictions where that was the last phase of the foreclosure process. The bank is upset with somebody, a homeowner, that doesn't pay their mortgage on and doesn't keep current on it. And so they have to go through some steps, but the final step in the foreclosure process is for the bank to file an eviction. And that is what physically gets the homeowner removed from the place. So there's some of those commercial rentals. There's some of those foreclosures built into that 16,000. So we've looked at these numbers every year for the last 5 years and done all kinds of reports for different areas. And that is our guess. It's an informed guess, but it is a guess. It's somewhere between 13 and 15,000 residential evictions that can be filed over the last 5 years. That's our best guess. How many are normally filed? This is pre-COVID-19. So we've got a baseline of 1,166 evictions per month. Now, evictions are somewhat seasonal. There are more evictions filed in the summer generally than there are in March or October. There is a dip in evictions generally in December. I think that landlords have some sort of holiday mentality that they don't want to file an eviction right then. And I certainly get that. But January, there's a big rush of evictions that are filed again. So there's some seasonality that happens with evictions, but evictions are filed all year. I mean, we get questions from renters on our tenant hotline where we take 15,000 calls a year where tenants will ask, hey, wait, I can't be evicted during the winter, right? And there's no prohibition against wintertime evictions. It's one of those things that tenants have heard, one of those myths of landlord-tenant law, but it's not true. A landlord can file an eviction at any time of the year, and they do. And again, almost always because the rent hasn't been paid. So that's our baseline, 1,166 evictions per month filed in Minnesota in a normal year. Okay, Eric, go on to the next slide. So here are some additional factors that we need to have in mind. All right, so the eviction moratorium, the official governor's moratorium on evictions began in mid-March. There are tenants, we have spoken with them. We have spoken with landlords who talk about this, that their renters have not paid rent since March. Even know some landlords that hadn't filed an eviction when a March non-payment was made. So some tenants out there haven't paid since February or maybe even January. But the landlord, once they decided that they wanted to file the eviction, they were barred from filing it by the governor's moratorium. But by and large, most tenants stay current. But there are a lot of tenants who haven't paid rent since March, or they didn't pay May or June. Maybe they paid April, or maybe they paid April and May, but they haven't paid June. But there are tenants that haven't paid a penny since March's rent was paid. Another factor. So you'll see numbers that vary wildly in the media about the unemployment rate, both nationally and at the state level. The most official version of the state assessment of the unemployment situation in Minnesota is that, and this is the most recent stuff I saw, but it was in June, is that the unemployment rate is 5 to 6% higher than at this time last year. So that is absolutely got an impact. There's no way we can't factor that into thinking about what we're thinking here. Now, when this all began in mid-March, the governor issued this moratorium on evictions really quickly in the process. Once it was decided to start shutting things down, one of the first things the governor did, there's been a 75 at least executive orders that I think have been filed, and this was like the 14th one, so it was pretty early on in the declarations by the governor. One of the things that a lot of us, both landlords, tenants, tenant advocates, people that work in this world were thinking of is, wow, this is going to be bad right away. This is going to be bad really fast. April 1, tenants aren't going to be paying their rent. We were getting questions from tenants, tenant groups, talking about rent strikes, rent cancellations, rent forbearance, because they were fairly convinced that they weren't going to be able to file or pay their rent in April because they didn't have any income coming in. So there's a lot of people that were working in the service industry, and they'd lost their jobs almost immediately because those were shut down because shelter-in-place orders. And so they didn't see how they were going to be able to pay April's rent. But unemployment has been easier to obtain for most people than I think a lot of us thought it might be. The federal stimulus package happened a little faster for a lot of people. Not everybody that is entitled to it has gotten it, but a lot of people got it a lot sooner than I think maybe we thought it would be, because it had never been done before. So the cliff, as far as, you know, when are tenants going to stop paying their rent, didn't materialize on April 1. I guarantee you, landlords were convinced it was going to happen then. We saw the notices that landlords sent, giant landlords, some of the biggest landlords in the state, the notices they sent to their tenants on April 1. We know that you might be having trouble paying your rent right now. Get to us with a reasonable estimate of when you can get your payments in and how much you can pay. And if you work with us and you set up some sort of reasonable payment plan, we'll waive your late fees, which is not required under state law, but it is required under the CARES Act. So there's no late fees allowed under the CARES Act. So if it's CARES Act coverage, no late fees can be charged. But anyhow, landlords were rightfully very concerned that the tenant ability to pay rent would be so damaged on April 1 that they sent out this preventative email or form to tenants throughout their network of tenants saying, we know you're going to have trouble paying, so let's see what we can work out, essentially. But that didn't materialize to the level that people were concerned about. Like I said, for the reasons that we talked about, some of the potential money out there that might be available to renters came faster and was in some cases more than we thought it might be. But there's what a lot of people are referring to, an unemployment boost, comes from the federal government. It's set to expire at the end of July 31. If there's a date that I'm most concerned about for this question, how many evictions are there going to be, what number, what percentage of tenants are going to be not paying their rent, that's the one I'm concerned about. July 31, sometime soon after that, tenants will have a lot less income available to them, unless things change. Everything we're talking about today is hinged on what we know today, not aspirational stuff. Is the state going to allocate more money to renters or to landlords? Is the federal government going to do that? Is unemployment going to be extended and increased? All of those things can change these equations quickly. But this is based on what we know today on June, what is it? June 24th, something like that. All right, so let's go on to the next slide. Okay, so yeah, it goes all the way. There we go, one more. Yep, you got it. How many tenants are behind? So this is hard to figure out. What we have up here are some statistics from a group called the Minnesota Multi-Housing Association. To my knowledge, I don't think they've ever reported this information before this year. They've decided to disclose this now, or maybe it's just more publicized now, I'm not sure. but they've been surveying some of their members. Minnesota Multi-Housing Association, a trade group for landlords. They do all kinds of things with landlords, but they work on lobbying. And I can't remember the number of members that they say they have. I think it's somewhere around 200,000. But they say this survey of theirs is of about 34,000 units. So there's 600,000 to 700,000 rental units in Minnesota that we know about. Okay. So this is obviously a small percentage of that, 5 or 6, but it's what we have that's focused on just Minnesota. You can find national numbers on this, which tend to be a lot worse looking than the Minnesota response to this question. Generally, what they're saying is about 80% of tenants are current on their rent, the national numbers that we've looked at. But this is a Minnesota specific one. So that's the one that we want to focus on, because when it comes to landlord tenant stuff, state specific issues are where you want to start if you can. So let's walk through what they've found. All right, so there are 3 classes of rental units that they use. These are their designations as near as I know. So the newest, most expensive ones, Class A, what they refer to those as. As you see here, 97% were current June of last year. June of this year, 94% are current. So 3% worse for current payments. Class B, and they call these 10 to 25 years old. Much less of a difference. 93% last year, 92% this year, so 1% worse. Now that still matters. I mean, if we're talking about 600,000, 700,000 units, a 1% decrease means, 6 or 7,000, I'm sorry, 600 or 700 more. Did I do the math right there? I think it's 6,000 or 7,000 more evictions that are tenants that might be behind. But then we go to Class C, where last year, 92% current this time, 88%. So a 4% decrease. So if you look at the Class A one again, that's actually double what it was last year at this time, right? We went from 3% to 6%. The Class C one went from 8% to 12%, which is another massive increase. And these are a lot of rentals that we're talking about. So when you start multiplying the percentages, this gets to be a lot of people that are impacted. All right, go on to the next slide. So just to sort of summarize this, what multi-housing has come up with, these aren't our numbers. These are publicly available numbers. It was in the Star Tribune. Let's see here. Got it right here because I kept the actual article. It was on June 15th. The business section is where we got these numbers from. And multi-housing has been sharing them willingly because they want their members and the public to be informed about what's going on. So again, this is summarizing it. June of 2019, we had a 92 to 97% delinquency rate. Okay, so that means 3 to 8% had not paid. June of 2020, it's 6 to 12%. So that's how much we've gone up. And that's before we reach the July 31 cliff of unemployment boosts stopping. Now again, more money might come from the federal government, more money might come from the state government, or even city or county government, I guess. Although we're all hearing about how every level of government is becoming strapped for cash, as almost all of their income is tied to tax revenue, which is based on transactions happening at all levels, right? Largely. So I'm not sure how much more money's coming at the government level for tenants to be able to access. So this might be as good as it gets right now, is somewhere between 6 to 12%. It could go up substantially depending on when the eviction moratorium is actually lifted. Okay, let's go on to the next slide. Okay, so yeah, one thing that we have been concerned about from the beginning, as I'm a lawyer, I represent renters, and we work with tenants that are almost all exclusively pro se, meaning they're not represented in court. And we have always been concerned, since I've worked at Homeline since 1996, about how courts move through eviction cases, how quickly they move. If you've ever seen a housing court calendar in Hennepin or Ramsey County, there might be 20, 30, 40, 50 cases in a calendar where it's only a couple hours. And I mean, if you just look at the raw numbers of time that it takes to get through each case, it's very efficient. So it's a real concern whether courts will be able to manage this. I also think that once landlords decide to file, there's no great incentive for them to wait. how I've always done this job is I always think about it from the tenant's perspective, of course, but I also try to think what's in it for the landlord? What's the best result for the landlord? And because you'd be naive to think about it any other way. Landlords don't do things necessarily because they're the moral or the right things to do. They look at the bottom line. This is a business they're running, and they look at our cost benefit analysis. And I think that most landlords, if they're looking at this, if they decide to file an eviction, and I'll talk in a second about whether they should or not, if they decide to file an eviction, there's no gain for them waiting to file. There just isn't. Next factor. Again, 1,166 per month cases have been bottled up. There's been a pause button hit on evictions in Minnesota. Almost all evictions can't be filed right now, so landlords have been waiting. So we're storing up 1,166 cases per month. They haven't been filed in April, May, June, July, part of March as well. I'm counting July because the eviction moratorium at the state and the federal level both go into July. So it's going to be at least 4 months of bottled up cases, which brings us to the number in bold. In my mind, this is the baseline minimum number of cases that are going to be filed, and quickly. Now, this could be off by a lot, but I don't think it's going to be higher than the actual number. I think this could be much lower than the actual number that's going to be filed, because this is essentially ignoring everything that we just talked about. The unemployment rate being much worse, the how many tenants have actually paid their rent being much worse, right? And again, that's a small sample size from probably the most professional landlords. And so I think it's probably skewed a little bit better in the tenants have been paying their rent sense than it probably should be. So this is our baseline number, 4,665. It could be another 1,000 or 2,000 or 5,000 more. This is our baseline number, though, that I think is realistically going to be filed as soon as landlords are able to file. Now, landlords might not be able to file it, again, if the governor ends the moratorium. Let's say it's on July 12th or July 13th. The governor decides to end it then. And July 14th, the landlords can go and file. Will they all go file? No, because a good chunk of them are barred from filing by the CARES Act. But if we wait into August, for instance, the governor doesn't lift the peacetime emergency declaration until August or September, when the CARES Act time limit has run out as well, then that number, first of all, we're going to be tacking on another 1,166 per month of bottled up cases, right? That number grows each month. And the CARES Act second hurdle that landlords have to get over is going to be less and less important. So this is our baseline prediction. And again, this is not a doom and gloom prediction. This is, I think, the best case scenario prediction for tenants and how many evictions are going to be filed by landlords. Again, if we just start looking at the percentages that haven't paid versus last year, we start realizing that has to be a low number. That has to be a low number. But anyhow, let's go on to the next page. Okay. So this is actually a really big question. I just mentioned that I always think about, in every case that I work on, what should a landlord do? What's in their best interest? What's the bottom line best they can do in this situation? And where we are right now is in a very unique spot. Landlords traditionally do not wait to file an eviction 3, 4, 5, 6 months. We've done all kinds of studies on evictions, and occasionally there's a landlord that'll wait 6, 7 months to file an eviction when a tenant hasn't paid rent, but it's really rare. Most landlords, if they're going to file an eviction, they file it in the first or second month after rent was due. That's just when they file it. But now all these landlords have been forced to wait. Okay. And the next thing to consider here is, what happens if the landlord goes and files the eviction and wins? What do they win? An eviction is a hurry up case. It's a summary proceeding, but it's a very limited case in what the judge or the referee, if we're talking about a housing court, has a right to even decide or consider. The judge's real job when it comes to an eviction is to figure out who has the right to possess this rental unit. That's it. That's their job. It's not who's going to get money. That's not what the court does. If a landlord truly wins an eviction case, what they win is they win possession of the unit. The easiest way I've ever seen an eviction hearing summarized as to what happens at an eviction hearing is, you imagine that at the beginning of the eviction hearing itself, the landlord and the tenant walk into the courtroom, walk up to the judge's bench and set all the keys in front of the judge. And then the judge or the referee decides at the end who gets those keys. That's really what they do. Now, sometimes a judge can give a key that'll only work for the tenant for 7 days or something like that. But it's really about possession. So if a landlord wins an eviction, they don't win money. They win possession. Okay. So is that what the landlord wants after 5 or 6 months of not getting paid, 4, 5, 6 months of not getting paid? Do they want possession or do they want money? Well, here's the thing. There's going to be some tenants that actually have some of the money. There's going to be a handful of tenants that have all of the money, that just didn't give it to the landlord, that saw this moratorium and said, well, the landlord can't do anything. I'm just not going to pay. I'll pay when it's time to pay. There's going to be some tenants that do that. There's people that pay almost no taxes all year and pay it all on April 15th of the next year. Okay, because a tenant can do that right now, so I guess some of them probably have. Most aren't withholding their rent. Most are paying. I mean, we're still seeing, well over 88% are paying their rent in Minnesota, according to one study we have. So most are trying to pay. They're not saying, oh, I don't have to pay, so I'm not going to. But there's going to be a good number of tenants out there that don't have all the money, but have some of the money. And they probably realized at some point, I can tell you what was in their mind because I've talked to them. I don't have all the money I owe, so what's the point in me making a partial payment? I don't have, I have April's rent, and they're talking to us May 15th or, the end, early part of June. I could pay April, but I can't pay May or June, so I'm just going to hold on to all this money because I'm not sure what's going to happen next, and I might need it to move into my next place. That kind of thinking is what tenants say. So if I'm a landlord, and I'm not, I've never been a landlord, but again, I talk to them all the time. I work with them because you have to negotiate. But if I'm a landlord, what I'm going to be thinking when this eviction moratorium pause ends is, what's in it for me if I win the eviction? Is that what I want, or do I want to try to collect money from the current tenant? So if I file the eviction and win, that tenant has to go. Now, I can go to another court, probably conciliation, small claims court. You can sue for up to $15,000 there. And I could probably win that case pretty easily. It's very likely the tenant won't even show up. But if I win that case, I don't get money. I get a piece of paper saying that the tenant owes me money, a judgment. It's going to cost me at least $70 more to get it transcribed. There's some other things that there are costs, but that doesn't mean I'm ever going to get the money. And that's how landlords really think about this sort of thing, is that they don't count on that money ever coming their way. If the landlord wants to get paid back for these 4, 5, 6 months that the tenant hasn't paid, their single best shot at getting paid is going to be to go to that tenant once the moratorium is lifted and say, you know what? The governor said that I can start filing evictions tomorrow, so I'm thinking about filing. Here's what you owe. I think you know it, but here's the dollar number you owe. What do you want to do? Do you want me to go file the eviction? Do you want to try to work out a payment plan where we can get you caught up? Do you want to leave today before the eviction's filed? There's going to be all kinds of leverage that the landlord suddenly has that they didn't have before. And a tenant's going to have to look at this as well. I mean, tenants have a strong interest in keeping evictions off their record if they can. This is going to be complicated stuff, and I really want tenants to be calling us when this happens on individual cases because it's really case by case. But tenants are going to have some decisions to make. But let's just assume for a second we're going to use, I don't know how many of you have watched our previous episodes, but we use the $1,000 a rent per month because it's easiest to do math that way. Let's say that that's what we've got. The tenant owes $1,000 a month per rent. So they built up a $4,000 or $5,000 debt. And the landlord comes to them once the eviction moratorium is lifted and says, I'm going to have to go file. You owe me $5,000. There's no way you have that money right now, right? Nope, I don't have it. Okay. Well, I don't see how you can get caught up. Well, actually, landlord, maybe I can. I started at work again. And I can't pay all $5,000, but here's what I can do. Instead of $1,000 a month, I can pay you $1,500 a month. $1,500 a month. Landlord's going to be interested suddenly. Because, well, it's not going to happen immediately. That tenant could get caught up over time. Might take 10 months to get there, but there's no law that says that the two of them can't sit down and write up a new agreement. It doesn't have to be that official or formal. You put the date on it, you put the parties on it, you say what the agreement is, and you sign it. And as long as the tenant lives up to it, I think both sides are locked into this new sort of modified version of a lease. If the tenant fails to make payments, then the landlord can go file an eviction. And that's probably going to be said in that document too. If the tenant fails to make any of these payments, then the landlord can go file the eviction. This is going to be happening a lot. Landlords are going to be trying that because they're going to realize this is the only way they're going to get their money back. That's realistic. Once that tenant vacates their actual unit, their ability to get the money from them goes down substantially, and landlords know it. Again, they might get the money. They might get a call if they went to small claims court and won. They might get a call 5, 6, 7 years later, where that tenant who owed them $4,000 or $5,000 calls up and says, "Hey, turn things around. Graduated from college, got a really good job, and trying to buy a house now, and they're saying I can't because I got this judgment against me, and I need to satisfy the judgment. So, what'll it take? If I give you $2,000, will you take the judgment away?" Which is a pretty common starting negotiation point in those situations. And the landlord might say, make it 3, and then they end up at 2,500. It happens, but it doesn't happen a lot, and landlords don't count on it because it's just too far into the future. They'd much rather get somebody in there that's paying on a routine basis. But if they can keep the current tenant and some money comes in, and especially if the tenant has some cash that day, a real number, right? I'm not talking about $50 or $100 when they owe $5,000, but if they have $1,500, the landlord's going to listen. They almost have to because this is the only way that we're going to see the landlord get paid in a guaranteed way. So while this number of evictions could be filed, and I think it's almost a given that they will be, that 4,600 number that I used earlier, the smartest landlords are going to do the cost-benefit analysis and talk to their tenants one-on-one and try to figure out what can be done. I mean, the alternative, again, evictions aren't free for landlords. It tacks on more money to what they're in the hole, right? To file the eviction, $300 just to start. They hire somebody to serve papers, which most landlords do, or at least most metro area landlords do. There's another $75 to $100. If they hire an attorney, that's going to be a minimum of $200 probably, maybe close to $500. You're looking at $700 to $1,000 to get that tenant out versus working out a payment plan, or maybe the tenant just agrees to go and keeps the eviction off their record. All kinds of options that a landlord has. Rushing down to the courthouse to file the eviction will happen, but it's not going to happen in every case. A landlord that thinks this through, their bottom line, not about asking a landlord to be a good person or anything like that, just what is the bottom line best they can do, might be talking to the tenant to try to work out a payment plan if it works in that situation. Okay, I think that was the last slide of the new stuff. Yeah.
It sure is. Thank you, Mike, for plowing through all that. We have lots of questions lined up in advance, as well as some that have come in. There's one that was very specific to the data stats that I'm going to have you answer first. Where
Sure.
did the stats come from? This particular person, Karen, owns a fourplex with 2 tenants who are not paying. Nobody has contacted me for any info as to if my tenants are paying. No sort of survey.
Yeah, Karen, that's a great question. I don't know exactly who Minnesota Multi-Housing surveyed when they did this stats. I have a decent sense of who their members are. They talk about having members that have 1 unit and members that have hundreds of units. But I think the majority of people that probably responded to this survey are the very large landlords. I might be wrong about that. I, again, don't know how they conducted it, but that's my best guess. And they just gave aggregate data that multi-housing put all together. And so, yeah, I can see why you're talking about a 50% non-payment rate. And that's why I'm saying that number I gave, that there's 4,600 bottled up evictions, is the absolute, in my mind, minimum number of evictions that are waiting to be potentially filed, or at least the landlord needs to think about filing them and maybe talk to the tenant about whether it makes sense to file or not. But yeah, it's a very, and this is a landlord obviously asking this question, not a tenant or a tenant advocate. We're only using the numbers that we can find because obviously Karen wasn't asked about her situation, and I'm sure that a lot of landlords were not asked. And so this number could be much higher. I would not be shocked if that number is double what I just named, the 4,600 number, based on the unemployment, based on the percentage that haven't paid, and based on what Karen just pointed out, which is, hey, those might be the most sophisticated big landlords. And so we're excluding from that survey landlords that don't have the giant empires.
Yeah, and then another very similar question came in from Roxanne. Do you have any data that's county or city specific? For example, what to expect in Hennepin or city of Minneapolis? I think that's something that we could maybe do for next week because these numbers are based on, some of the numbers are based on previous years, and Hennepin and Minneapolis are the sort of the highest filing areas, but we could maybe try to pull those numbers.
Yeah, fair warning about next week. For the first time, somebody else is going to be sitting in this chair. Well, actually, not true. I'm at home, so he's not going to come to my house. I'm not going to be here next week, though. Samuel Spade, another attorney in our office, who's actually, wow, I can't remember the title he has as far as when it comes to this. Do you remember what it is, Eric? The stats that he keeps. Hotline research coordinator, is that what it is?
He's our research director.
Research director. Wow, I'm glad he wasn't listening, so he'd be insulted that I didn't know the exact job title. He's an attorney that's been working with us a long time, and he would actually be able to pin down those stats on the Minneapolis and Hennepin County just as well as I did, because I was using his reports. So yeah, you could have Sam cover that next week as part of the focus to talk just about Minneapolis and maybe Ramsey County as well, because we have some good numbers on those.
Yeah, and then all right, so let's get to some of these questions.
Sure.
We did get another quick question. How will Homeline deal with the increased need for their services? So, you know, we've been thinking about this since early March, and we're working on it. We've been ramping up some staffing and we're
volunteer hours.
Volunteer hours, and we're not alone. You know, there's many legal aid offices throughout the state. I'm sure there's folks from legal aid offices on right now that are preparing for this, but it's a difficult thing to really prepare for when we don't know, you know, an exact date, but we were preparing. So so I'm going to jump to these questions.
These are the pre-submitted ones first, right? That's
yes.
what you're starting with? Okay.
Yes. Will there be significant wait? And some of these are going to be repetitive, so just jump or not. Will there be significant wait times for court dates?
Okay, we actually haven't talked about that. Normally, a landlord, if they file an eviction, they're guaranteed court within 14 days of filing. That's the standard rule in Minnesota. That's the guarantee that a landlord has when they come to file an eviction. The legislature, along with the governor, passed a new law during COVID-19 saying that statutorily set deadlines like that can be relaxed or ignored to some degree. Also statutes of limitations, which isn't really what we're talking about here, but it covers those as well. We have heard indications from Hennepin County, from Ramsey County, that they're going to try to stick with that 14-day rule. I think it's going to be logistically almost impossible. I really believe that there is a chance that that 4,600 number that I mentioned earlier, that could happen in one day, depending on CARES Act involvement when that gets triggered as well. We've heard from other jurisdictions, other states, where evictions have started again already. Columbus, Ohio, they have taken over an arena for housing court cases because they don't have enough room to do evictions in their court system. And they're trying to socially distance, obviously, but they need more space. And the arena is not being used for anything anyway, so I guess that makes some sense. But physically, there's just no other way they can manage it. But just thinking about that we need an arena to process evictions is, in Wisconsin, landlords were lining up in most of the metro areas hours before the courts were open, like it was tickets to Hamilton or the hottest concert, so they could get in line to make sure that they had their evictions heard as quickly as possible. If landlords decide to file an eviction, as I mentioned, there is no incentive for them to wait. Again, I think a smart landlord is going to think, is the eviction the right move for me? But if it is, they're going to file as soon as they can. And again, the CARES Act might require a 30-day notice, so that might mean this is split into 2 different sets of days where evictions just happen all at once. But I think it's very possible that we're going to see hundreds. I mean, on average, it's 270 evictions filed per week in Minnesota pre-COVID-19. We could have thousands filed in a day. And it's just not, like I said, doom and gloom thinking. It's just if landlords think this through and they decide to file, why would they wait? And so that's a real concern. Can the courts logistically possibly manage this throughout the state? Hennepin County and Ramsey County have the most evictions filed, but there's plenty of other counties that have hundreds, if not a couple, have thousands of evictions filed in a regular year. They're going to be dealing with massive numbers. And these aren't the only court cases. Those courts here, outside of Hennepin and Ramsey County, where we don't have any other housing courts, it's district court judges. They're going to have all these other cases backed up too. And so they have to try to squeeze in the evictions when they can. And again, a big concern is sacrificing what we want, the standard minimal due process for judicial efficiency is a real concern for people in my line of work.
All right. Are there protections for renters who will be evicted since the governor set this in place, or are they on their own?
Well, the governor could set up extra protections, I suppose. the governor could say, look, I'm going to end the eviction moratorium, but a landlord's got to give a notice first. So that's what the CARES Act does. It says that a 30-day notice has to be given. I guess if the governor really wanted things to be clean, they could try to parallel in time the CARES Act rule, right? That say, you know what, we're going to end the eviction moratorium on July 25th, but a landlord has to give a 30-day notice, just like under the CARES Act. And that would line all of them up, I guess. Otherwise, it's going to be sort of a jumbled legal question whether the landlord has the right to file the eviction. But an extra notice to the tenant would be ideal for a lot of reasons. Number one, the tenant would know, okay, this is when my drop dead date is. I got to get out by then or else the eviction happens. Or they can go to try to get financial assistance. They might qualify for financial assistance from emergency assistance or another social service provider or a church or a friend or family member, because they can show whoever they need to show that this is a real threat, that they haven't been paying their rent this long, this is how much is owed, and that if they don't meet this deadline, that the eviction can be filed. So a notice, if the governor required some sort of notice, which I assume the governor can give an executive order saying that too, I don't know why the governor couldn't, that would be a substantial protection that a tenant would have. In Minnesota, as things stand, pre-COVID-19, the landlord didn't have to give any notice at all. There was no legal requirement. We're one of only a handful of states that had that rule. But if a tenant's rent was due on the 1st, the landlord could go file an eviction for non-payment on the 2nd. Now, most landlords don't do that. Evictions are money losers for most landlords, but they could. Legally, they could. And so without some sort of notice requirement, it is, if I were telling the governor and the governor were listening to me and they said, well, how do I protect tenants once the eviction moratorium is lifted? I'd say a notice requirement, hopefully a substantial one, something like 30 days, or we've seen 60 days in other states, would make a huge difference in minimizing the flood of displacement and almost certain homelessness for a lot of people once the eviction moratorium gets lifted.
Right. Health hazard notice from health inspector during COVID.
I'm not sure how much I can answer that. There's just not enough information. I assume this is a tenant. And what I would recommend that you do is you contact our tenant hotline. It's free, or you can email an attorney directly. Eric will put those both up in the chat box, both our phone number for our free tenant hotline, and you can talk to one of our tenant advocates. Or, like I said, you can email an attorney directly. We'll need a lot more information to be able to give you any advice on that.
All right, I'll put that in a second. Are there new programs that have been developed to assist those affected by this housing crisis?
Yeah, I mean, there have been some city programs that came up. I think those have been expended mostly in the cities that I remember reading about throughout the metro area. There may be more. I know at the state level, there have been both in the Senate and the House, some proposals to try to get some money to some renters. That might still happen if the landlord extends the peacetime emergency declaration again next month. A special session is automatically started by law once again, and the legislature could get together and try to come up with some sort of package deal. That might be how this all ends, by the way. The eviction moratorium all ends is some sweeping deal is reached on a lot of different issues between the House and the Senate and the governor. And there's an agreement on when things phase out, like eviction moratoriums, and how much money might be allocated by the state. So it's something to keep an eye out for sure.
I'm a landlord who lives with his tenant. I'm thinking about installing security cameras to the exterior of the property. Am I required to provide the tenant with a notice?
Yeah, this is a different topic for sure. And by the way, this program was designed for tenants and social workers. We have no problem with landlords watching. We got a question earlier from a landlord. This is obviously a question from a landlord too. Tomorrow's session, we try to tailor a little more to landlords and property managers. You're welcome to watch that as well. It's going to be a lot of the same information. But anyhow, I don't know of any law that requires a landlord to disclose that they're installing an exterior camera. There are all kinds of privacy concerns about an interior camera in the common areas that you share with the tenant, where they think that they're in their own private space. I think that's very problematic. But in the exterior area, it's probably okay is my best guess. I'm not sure that I've ever had to look at that from the question of a landlord living with somebody in the same unit or same space, whether they can install an exterior camera. Landlords install them frequently in large buildings. And again, I don't know of any law that requires them. You see signs up almost always telling people that there are exterior cameras, but that's largely for deterrent purposes. They want to convince people to not commit crimes. So that's why some people use dummy cameras where it's not a real camera. It just looks like a camera. And the hope is that will deter crime.
Tenant got written notice on March 24th that the lease would not be renewed, asked to vacate on June 30th. What are her rights with the executive order? I think 2014 was March 23rd, right? I'm going to check.
Honestly, it wouldn't matter right now about the dates on this one, Eric, because it sounds like the notice to vacate was effective for the end of June. So we didn't talk about this week to try to get to some other topics, but the governor's eviction moratorium also stopped landlords from terminating tenancies during the peacetime emergency declaration. And this would clearly be one where the tenancy would be terminated during the peacetime emergency declaration, which is extended through July 13th at this point. So a June 30th end date for when the tenant is supposed to vacate. What can the landlord do on July 1? The normal approach a landlord could take in a pre-COVID world would be to go file an eviction on July 1 for what we call holding over. But they can't do that now because the evictions are blocked, as are the terminations of tenancies. Those are not allowed as well. So yeah, it's I think it's an invalid notice, certainly, unless, I guess the governor could end the peacetime emergency before that time, in theory. So then it might still hold up, but that's only if the governor or the legislature, which would have to be back in special session, and they aren't right now, decides to end it before the end of this month. Otherwise, I don't think that's a valid notice to vacate because of the governor's order.
Related, what is the status of notices to vacate? Are they voided or just pushed back until enforceable?
Yeah, I think they're voided, and I think they're clearly a violation of the governor's order, the executive order, which means it's a misdemeanor. So that is up to 90 days imprisonment, up to $1,000 a fine. The Attorney General's office is allowed to enforce that, and they have been enforcing it. They are talking to landlords on a regular basis where they get complaints from tenants and trying to talk landlords down from doing things, but they've had to actually go to court in several instances.
And I'm a month-to-month, and now landlord wants to move. The landlord wants to move in on July 1st. What are my options? And they have
there's no special exception for a landlord wanting to retake possession for personal use or for a family member or anything like that right now under the governor's moratorium on evictions. You have to sort of keep in mind, what was the governor trying to do here with the eviction moratoriums? Was it to somehow punish landlords so they wouldn't get paid or reward tenants extra? No, it was to make sure that people weren't moving around that didn't need to be moving around. We wanted everybody to stay in one place. And to a large extent, we still want that to happen. And so that's the theory behind this. And that's why there were so few exceptions built into the eviction moratorium. And there's no exceptions built into the tenancy termination other than the safety of other residents being the only other concern. So yeah, the governor could have put an exception in there for if a homeowner wanted to retake possession of their own place so they could live there themselves, but the governor didn't put that exception in. So a notice by the owner to move back in at the end of June. Again, what if the tenant refuses to go on July 1? The landlord can't file an eviction. Their one main remedy isn't available to them until the governor lifts the moratorium on evictions and terminating tenancies.
All right, we still have about 10 more or more than 10, so we're going to keep plowing through them. We might go over a little bit, but we're going to try to get to everybody's question. How might we petition the government for an extended moratorium?
Again, there's two parties that really matter here. There's the governor and there's the legislature. So you can contact the governor directly. You're a citizen of Minnesota. You have a right to contact your governor and say what you want to have happen. You can contact your own legislator too, both at the House and the Senate level, and tell them what it is you're hoping for exactly. You might think that it doesn't matter, and maybe one person calling and asking for it doesn't matter. But when lots of one people call or write or email, then it starts to count up. And so if you want to change what's going on with that, contact the people that are actually in power, which is the governor and the legislature.
When applications are denied due to criteria prohibited by the new Minneapolis ordinance, what do we do?
You'd contact the city directly, who has the power to enforce that ordinance. It's a brand new ordinance, went into effect on June 1. And so if there's a violation, the city is the entity that has the most ability to enforce that. And so that's who you should contact as a city, by probably starting by calling 311.
Yep, 311 will get you to Regulatory Services, who's the department that oversees this. We'd also encourage folks that are in that position, give us a call. We can talk through the situation a little bit more and perhaps provide additional advice. And legal aid, Minnesota Legal Aid in Minneapolis is also assisting folks. We'd refer folks there too. Next question, our amenities were closed until recently related to COVID. Management wants a waiver sign not to sue before tenant uses again. Is this legal?
Okay, so the tenant is asking about whether or not the landlord can stop them from using these amenities once they open them up again if they don't sign a waiver. I don't think the landlord can mid-lease do that, no. Maybe at the end of the lease, the landlord has a better argument for being able to do it, but a landlord can't simply change a contract midway through the deal, just like a tenant can't change a contract midway through the deal. So requiring that a tenant fill out a waiver is probably unenforceable. I don't see how the landlord could force the tenant to do that. Amenities are something we've dealt with on a fairly regularly since COVID-19 kicked in, and hopefully Eric will put up the position paper that we drafted on amenities and what a tenant can expect for compensation in the amenities arena. It's not directly answering that question, but I don't think that a landlord can do that in the middle of a contract. It would have to be at the end of a term, or if it's month to month, if they gave enough notice. And even then there's some issues with it, but it's probably legal.
Yeah, I'll get that link up shortly.
Thanks.
Are you going to include HOAFC? I think that means Homeowner Association Foreclosure. This is a huge concern of mine in Dakota County. The housing market is a quarter townhouses and condos.
No, I'm sorry. Condos, townhouses, co-ops, associations like that, unless it's an actual rental, that's all we deal with. I apologize and hope we weren't misleading you with that what we're promising to talk about. We're a tenant hotline, tenant rights group, and that's what we do and what we focus on. And I realize there's a gap for folks out there that are in condos or townhouses, or especially co-ops, where it's not easy to find good, useful information, certainly that's free. But unfortunately, it's not us that can advise you. At a condo or in a townhouse, there are some attorneys that do that work that sort of specialize in it, but I don't know of any of them that do that kind of work for free. You'd have to contact them and see if they could give you a consultation on what they charge you.
Yeah, and the Minnesota Homeownership Center would be another resource that I'll link to.
Yep.
What to do when housing application, oh, sorry, we already, that one was in here twice. Alyssa today has asked, I was told yesterday by the Minnesota Multi-Housing Association that we can file evictions right now to get in the queue. What's your stance or understanding of that?
You can file an eviction for somebody that has drugs or guns or illegal guns, illegal drugs, prostitution, contraband, domestic abuse in the property. You can't, or for endangering the safety of others. As far as filing an eviction right now to get in the queue though, I'm not sure exactly what they're referring to then, because that seems like it would be a direct violation of the governor's moratorium on evictions. I think it would be a misdemeanor to file an eviction for any other reason than those exceptions that are granted. So I don't know where they got that info from. It seems like it would be directly violating the governor's order.
All right. Are there any restrictions on landlords not renewing leases? For example, if someone is on month to month or have approached the end of their lease, does the landlord still hold the right to not renew the lease during this time?
I'm sorry. Say that one more time. I lost it midway through.
Yeah.
Oh, here it is. From Dave?
Yeah, from Dave. Yep, from Dave.
Okay.
It's basically, can a landlord non-renew?
Oh, sure. I understand what you're saying now. Yep. The general rule, Dave, is that a landlord can non-renew usually for no reason at all. There's a few exceptions to that, but by and large in Minnesota, a landlord does not need a reason to not renew a lease. They can simply decide to non-renew somebody. So you're not really asking about the reason, but you're asking about the timing. Right now, I don't think the landlord can terminate the lease. Even if they were giving a notice for instance, for the end of July at this point, past the peacetime emergency declaration we have in front of us, the governor might extend that. And I think that giving the notice right now is a termination of the tenancy. And the Attorney General's office has been actually telling landlords that they need to back off their termination letters.
Okay, I'm going to try to go in order here. We're going to go to one of the Q&A ones.
Mm-hmm.
Emma, another question related to the new Minneapolis tenant screening ordinances. Emma recently encountered a property manager who refused to even schedule a showing with a prospective tenant because her income did not meet their 2.5 times the income requirement. Is that illegal? Would we need written documentation from this property manager in order to pursue legal action?
So Emma, written documentation would always help. And by the way, we've hit 2:30. I don't mind sticking around. I'm sure Eric doesn't mind sticking around to answer these questions. And that's what we're going to be doing the rest of this time, is just answering questions that have been submitted now. But you're welcome to stay and listen in. Happy to have anybody that wants to listen. Anyhow, anything in writing would help. And a lot of people these days are contacting landlords and communicating almost exclusively in texts. And you might think, well, is a text good enough? I'd certainly use it, right? One thing I'll tell you about text, if you have a text that you think is valuable, get a screenshot of it. If you break your phone, you lose your phone, you get a new phone, it can be really hard to ever recover that information that was on the phone. So would it help to have it in writing? Yes. Is it absolutely necessary? No. The tenant can still relay their version of the story and the city can investigate on their own, is a short answer.
Okay, and then Dave, another Dave Anderson, chatted in, the exception to non-renewal of leases is for manufactured home parks. The proper notice for ending a park lease is one of the 8 reasons allowed for under good cause eviction. Courts have
And Dave is right. There's some subsidized housing as well that has limitations on, that require what we call good cause non-renewals. But Dave is right. Manufactured homes, that does count for that exception.
All right. Okay, you got the Dave one. And then we've got Anonymous. Anonymous's lease expired in April. They've continued to stay in the current place. Can the landlord evict? Landlord has refused to renew their lease, continue to accept May and June rent, which is discounted rate based on the rent in the prior lease.
Well, the landlord can't evict right now. We have the eviction moratorium in place. The harder question is what happens once the moratorium is lifted? Probably what's happened here since the landlord has accepted rent in May and in June, past when the lease expired in April, is we've rolled over most likely into a month-to-month tenancy by law. At that point, once the moratorium is lifted, then I think the governor, the landlord here likely could give a notice for the end of the next rental period. So probably the end of the next month. So let's say the governor's eviction moratorium ends on July 13th, then the tenant could give a notice, the landlord could give a notice on July 14th for the end of August, would be my best guess based on the facts that I have in front of me, but not before then.
All right. All right, now we're going to jump back here. Just to note, these new cases don't, and this is going back to your discussion about the stats, eviction stats. These new cases don't take into consideration the cases that were already filed but have been held up due to the courts closing in March, correct?
Yeah, and that is some cases, but it's not thousands. I don't even think it's hundreds of cases that we're talking about. But you're right, I did not factor those into that number. So that number makes it a little bit higher if we're talking about that. They're trying to process those cases now to some degree. And those will be the first ones that happen once the eviction moratorium is actually set in place, but yeah.
All right. Anonymous writes in, I have a client that had received a 30-day notice on June 6th. Landlord indicated he did not need to give a reason, but with conversation alleges another tenant's car was broken into, and the person from the tenant's unit, the person that did that was from the tenant's unit. Should this tenant wait until the eviction is filed? Is this within the CARES Act? The notice was given to the client to vacate on July 6th. There is other issues with this landlord that is encourage the client to continue paying the portion of rent that is due.
Yeah, look, we'd want to talk to the tenant directly about this. Obviously, they can again call our free hotline, or you can help them email. If they have trouble with that sort of thing, you could help them compose an email to an attorney directly, but we'd want to know all the facts that are relevant here. A couple things that stand out in my mind. This notice that you're mentioning here probably has no real legal effect. Even in a pre-COVID-19 world, a 30-day notice like this, where there's a mid-month end, where the tenant's supposed to leave by July 6th, probably a defective notice. That doesn't mean the landlord couldn't file an eviction pre-COVID-19. They could say, hey, the tenant breached the lease, they did some bad stuff, they should be evicted, and try to convince a judge to remove the tenant. That could happen still. And what I'd be doing if it was pre-COVID-19, I'd be talking to the tenant about sort of the cost benefit. How much does the landlord have? I'd ask the tenant directly, did this happen? If it did, then the landlord might have a strong case, and maybe it's in the tenant's best interest to leave before the eviction is filed, keeping the eviction off their record. But we're in COVID-19, makes it harder to file an eviction. The standards are higher for landlords. There's just so many facts that need to be learned here. Like I said, have the tenant get in touch with us directly if possible.
Okay, and then we're going to jump to this one. What if a tenant across the hall installs a Ring camera? Is that an invasion of privacy? A Ring camera is one of those doorbell things that is like Wi-Fi connected, I think, and you can, if somebody rings it, then it pops up on your cell phone.
Yeah, we've gotten questions similar to this in the past. I don't think that this is a violation of the neighbor across the hall's privacy enough to warrant any kind of legal response. If the tenant, or let's say anybody, is installing some sort of surveillance where they can see into your home even when the doors and windows aren't open, they've installed some hidden surveillance, so they've shoved something under the blinds or whatever, that's clearly illegal. But having a Ring camera like this for the purpose of seeing who's at their door, I can't imagine that a judge, just sort of thinking about this in court, that's how lawyers think, would say that that violates the neighbor across the hall, their privacy.
All right, sorry, I'm in Homeline's office, and our landlord came in, so all right. Okay, Anonymous asked, do we have any sense of how the housing court hearings will take place? For example, if a tenant is high risk for COVID-19, will they be video calling in? What if they are low income and don't have access to internet / a smartphone?
Yeah, we're going to be talking about this at length at some later meeting, because once the evictions are more imminent, honestly, we're going to be covering that. It's likely that there's going to be phone call-in cases. They're going to be Zoom cases. Maybe the tenant is allowed to appear in court. It's going to be really difficult. Logistically, just a lot of new ground that has to be covered. And so these are fair concerns. The tenant is out of minutes, right, on their phone, so they can't appear in court. And another concern from a due process line of thinking here is that how we want to decide that somebody loses a case because they don't have a good new phone? Is that why they should lose their home? And that's just a disturbing notion, that would somehow be why somebody wins or loses a case, but I'm almost certain that it will happen, that tenants will lose cases because they don't have a working phone, or their phone cuts out, or they are in a place that has bad cell service at that moment. And so, yeah, how to make those work effectively is going to be a giant challenge for the court. And we're going to be observing as many of these as we can to keep an eye on this, so we can sort of let the courts know all around the state, this isn't working or this is working. And so we've been trying to observe as many cases as we can right now to keep an eye on that as well.
All right, we got maybe 3 or 4 left here.
Sure.
This one, I'm not sure we can answer, but is this notice in violation of peacetime order? So if you're a tenant, I mean, feel free to give us a call. We're happy to look at notices to vacate. Most in this time would probably not be allowed under the executive orders. Christina asks, what is considered endangering the safety of others? So the ordinance says endangering others. Landlord not renewing lease, asking tenant to vacate on June 30th for this reason. This was news to the tenant.
So this is sort of a loose standard. It's hard to pin down, but I start always with sort of the restraining order / order for protection kind of standards that we look at, which is, did somebody physically attack somebody else? Did they threaten to physically attack somebody else? If you've got that, then I think that's clearly endangering the safety of others. Anything short of that, it starts to be more speculative. And I don't think that a landlord's footing is that firm on those cases. This is a high bar. Landlords aren't supposed to be able to kick people out just because they couldn't do it for non-payment of rent, so this is an alternative. They've got to be able to show, the burden's on the landlord clearly, to show that the tenant is endangering the safety of others. So it is a vague standard, but it's not a low standard. It's something the landlord's got to get up to that level.
Okay, Anonymous has a youth who wants to break her lease because she does not feel safe in the neighborhood. She's received multiple crime alerts and recently approached by a guy asking to get in his car. She expressed her concerns. Apartment manager has not responded to her concerns. Can this tenant break her lease on her own, again, out of concerns of her safety?
Short answer, maybe. Once again, I want them to contact our tenant hotline directly. The phrase that it's a youth implies that maybe they're under 18, which brings up a whole host of legal potential options for the tenant. So I'd want them to email or call our tenant hotline directly. Without that factor there, it's a tougher argument. I mean, there's an argument to break the lease, but we'll walk through the options the tenant has, which might hinge a lot on how much the rent is, where it's at, where the apartment is physically at. But yeah, we'll want to go case by case through that.
All right, I think we're to our last question here. So I want to remind everybody to put up on the screen that we are doing these weekly. We'll do them again next Wednesday at 1:30. Mike won't be here, but Samuel Spade, our housing attorney and research director with Homeline will be. And the recording of this will be available on our website probably later today or tomorrow. You'll get a follow-up email with the registration and the for next week, as well as a link to the recording. And again, on our website, homelinemn.org, top right, there's a COVID-19 tab, and it has drop down to our general information page and links to the upcoming webinars and recordings. Okay, so this last question: if a tenant in an apartment building is illegally printing 3D weapons, creating an unsafe environment for other tenants, is the landlord legally required to intervene? Could a tenant get out of their lease due to this fear? This is a question from Madison.
Okay, so again, I've been doing this since 1996, and one of the things that I like about my job is I still get new questions. And this is a new question. I've never dealt with a illegally printed 3D weapon question. There is a list of weapons that are illegal to possess, and I don't know if there's some specific 3D mention. I know there's not in the statute, because the statute was written a long time ago before 3D weapons would have been even a science fiction possibility, really. But it depends on what the weapons are and how they're defined. But a landlord might be able to file an eviction against that tenant. Now, could a neighboring tenant get out of their lease because the landlord is refusing to enforce that? Maybe. Neighbor types of disputes are difficult to deal with. It's possible, but I would want to talk at length to the tenant about any other fears, and again, how long their lease is, how much their rent is, and a lot of other factors. So I'm not trying to bail out on these questions. It's just many of them, I need so many more facts that you can only get with an in-person interview. And so I hope that they can give our tenant hotline a call or send an email to our email and attorney service.
Okay, well, that I think concludes all of our questions, unless I'm missing something. I think we got them all. So again, thank you. We appreciate that you're all joining us. And again, you'll get a follow-up email, and hope to see you next week. Thanks all.